in terms of murder. I can tell you that right now. So anyway, because it's a partial defense that bring it from that to manslaughter. It's a statutory defense actually, right? Now, it says that if after the defendant has acted, some other act or event were to occur, bringing about the prescribed result, the defendant may escape liability. So you have cases like Smith, Jordan, Cheshire, Roberts, Williams and Davis. Blow is the case. You take your victim as you find them. Dare and Kennedy. These are some cases that, and then there's a case called Holloway. I don't ask me why I remember all of them. I remember them, but I just want to say to you that when one goes and makes the assessment, it's an interesting thing. What people do, a beer lawyer up on the live right now, you know, them research the case, have the case. I'm so proud. I'm proud of you. Proud of you for checking it. I used to say blah, but if you are studying for exam, you say blow. Sound like a firearm. Anyway, so there are some general principles of causation. A defendant's actions need not be the scientific or medical cause of the result. Defendant does not need to touch the victim. So sometimes you can frighten somebody and them run off and hurt themselves, and you are the reason why the person harmed themselves, and you're liable for that. For instance, in the case of Roberts would have almost kidnapped a girl and she jumped out of the car and hurt herself. He was liable. In the case of Williams and Davis, they were giving the person a ride, and the guy was like, oh, these guys look like they're gonna rob me, and he jumped out of the back seat and he ended up dying, and they were not found guilty because they didn't do anything. So that's the thing about need not touch the victim. Well, the defendant must take the victim as she finds her. So remember, if you decide, say, you're gonna walk up to a girl at a party and box her, and she have fits or sickle cell or blood thinning disease, and when you box or thinning skin and you box her and she bleed to death, you have to take your victim. If you hit a girl and she's Jehovah's Witness and she doesn't want a blood transfusion, problems that. If for instance you decide, say, you hurt somebody and them say, yo, only pork can save the person. Some Boston jerk pork can save the person, and then the person is a Rasta, and the Rasta man say, no, I'm no pork. I forgot, just unalive me. And then he dies, you're still responsible for that. And that is how the law actually works. So the defendant's acts need not be the whole cause of the consequence. So how causation works and criminal liability works is that once you have started the chain of events, the cost.
To give us some clarity. Morning, Matthew. Welcome to Smile. How are you, sir?
Good morning. I'm great. Thank you for having me, Neville.
It is a pleasure. Delia is with me. Let me start.
Hi, Delia. How are you?
I'm good, thank you.
Let me start, Matthew, with a bit of a strange question here. I know you will have events, and on the flyer and stuff, you'll see no firearms allowed. I know that.
Yes.
If that doesn't happen, is there anywhere that you shouldn't have a firearm, even if it's a licensed one? And I say anywhere like maybe like a Champs or something like that. Is there anywhere, if you don't see that sign, that you should not have a firearm?
That you should not have a firearm. Well, generally where you have a licensed firearm holder, he's allowed to take that firearm with him on his person.
Yep.
But as you said, Neville, when I go to events, the flyers normally say absolutely no weapons allowed.
Right.
And even during the soccer season, even my very cooler was searched. in order to ascertain if there is any illegal weapons. So not only firearms, but any weapon at all. So it is very strange to me that you do have some events that patrons are actually having weapons inside of those events.
Yeah, but if the event that you went to did not say no firearms and they found you with a firearm, I mean, I'm talking about licensed firearm.
A legal firearm.
Legal firearm. Would you be in problems?
I don't think so. Not at all, because I'm a licensed firearm holder.
Okay.
So I am allowed to.
Okay.
So there is nothing necessarily in the legislation that is preventing a person from bringing their firearm to any event or in any area.
Yeah.
Once you're a licensed firearm holder, of course. But normally the events do say absolutely no weapons allowed. And so apart from, let us say, the security personnel who may be allowed to have their firearms, I'm not expecting that ordinary patrons inside of an event would have their firearms.
Yeah, sorry, Matthew, just before data, I asked the question because in this thing that we're talking about here, everybody say, so why would you want a man have a gun in a place like that with so much people and all kind of thing? That's the reason I asked that question, and thanks for the clarity. Data.
All right.
Yes.
And I think we did have this discussion with Pierre Rogers some time ago, but just to remind us, in Jamaica, what does the law say about a person's right to defend themselves? I know this is one of the laws in the U.S. that from time to time becomes contentious because they have their own laws. What are the laws that pertain here?
Well, the law allows a person in Jamaica to defend himself. You can defend a third party. You can also defend your property. And once you raise the defense of self-defense, it is considered a complete defense, meaning that once it is raised in court successfully, then you get to go home. However, it is a law in which you have to establish, or defense rather, that the use of force in these circumstances is necessary and it is proportionate to the level of threat that exists at the time. In fact, there is the classic case called Beckford and the Queen that illustrates the test for self-defense. And it is that a person may use such reasonable force as they deem necessary where it is that they honestly believe that their life is in danger. And the honestly believing that their life is in danger is very important because that is a direction that a judge will have to say to the jury for them to explain and understand what it is and what are the circumstances under which a person might have used such force to defend him or herself. Because the law does not say that you have a duty to retreat. So if somebody should come inside of your house, for example, to rob you in the dead of night, then the law allows you to use such force as is necessary if it is that you have a firearm to protect your property. You may have your wife and kids at home, and so you are allowed to use such force. So you have no duty to retreat. And it doesn't necessarily mean that it involves the use of a firearm. It can be that a group of persons are coming up at you. It could mean that you perceive that the threat is such that some of the persons may be armed and that you may be attacked, and you honestly believe that your life is in danger. The law permits that you can use such force as is necessary in those circumstances.
I'm going to throw one at you, Matthew.
Yes.